how the process works, what they need to do. But those are the resources we have available. We do have experts in the national office. If there's a serious policy question that nobody seems to be able to help you with, we can answer that. Senator Claire McCaskill has said that she would make a thorough investigation of all the health problems caused by the radiation and hundreds of known toxins used at the plant now run by Honeywell in Kansas City. To your knowledge, has she done that? If she has a report been released? If so, how can we get copies? We're not aware of anything that Senator McCaskill is doing. You'd have to contact Senator McCaskill. Why has the Honeywell plant in Kansas City not been designated a special exposure cohort? SECs are done by NIOSH. I can't address NIOSH and why. That would be a NIOSH question. When the Department of Labor evaluates a claim for benefits under the EEOICPA, do they consider the exposure of just one toxin for the cause of an illness, or do they consider the synergistic effects of several toxins? The synergistic effects of several toxins can cause an illness and or it can result in the compromise of the immune system, which in turn results in an illness. We consider all potential exposures that workers were likely to have experienced in the, and we consider them in conjunction with one another. Again, we rely on medical evidence. We need a doctor to help us with this. We can either get it from the treating, we can get it from a CMC. NIN may be able to help us with certain synergistic effects of certain toxic substances together. But that's what we rely on for our case files. Without contacting all of the past and present employees of the Honeywell plant in Kansas City for information about their health problems, how can an accurate assessment be made of illness clusters in the plant? Surely the Department of Energy and or the Department of Labor can obtain a complete listing. Then each employee or relative, in case of a death, could be contacted for information. Has this been done? If not, why? This is a workers' comp program. We're not a research program. Unfortunately, we don't have a dedicated set of people to do research on each individual facility that we have. We try to compensate people, with the evidence that we have in the file. In terms of reviewing clusters, the study of that is a scientific endeavor, which goes beyond the scope of our mandate as administrators of the program. There's also an entire legal framework with regard to the Privacy Act and contacting claimants that we really can't go beyond and just kind of blindly start calling people up and asking them these sorts of things. It's really kind of outside the realm of the scope of our mandate. Are you going to make a conference transcript of all the presentation material and questions and answers available to all the people who want it? It is essential that the information be published and made available. If you are, how can a copy be obtained? A lot of these presentations are in your workbook. And, I'm happy to put any of them up on the website if we need to. My questions and answers, I can write them out after and send them to Denise. I didn't do that yet, but I can do that. So that's kind of how we're making it available. I see that it's being recorded anyway, so I don't think you need to worry too much about it. When the Dayton Project Monsanto Part E statistics, when would they start showing up on the statistics webpage? We've had a little bit of a struggle with this only because of the name change. The name change has caused, it makes them a DOE facility, but it also changes the definition that NIOSH put in for the SEC. We need NIOSH to change the name in order for us to process those as SECs. Unfortunately, that's a legal thing. We absolutely need it to be the same. We are in the process of changing that in our ECS system. That should be coming up very soon. As I just mentioned, we have a new system for tracking these things. That is happening. And I was told right before this meeting that we're going to hopefully have that change up on our website either this week or next.
Thank you. I was just curious.
Okay, those are the written questions that I received prior to this meeting, and I'm happy to take more.
The IOM results that are going to be coming out, is there going to be a process for reviewing and adopting those? Is it going to be transparent? See, so far the meetings have been, when they meet to discuss things, it's been really transparent. And so when that result comes out, is there going to be discussion about it, or is it just going to be interdepartmental stuff? Are we going to, hear and see what's happening?
I haven't actually gotten that far yet in terms of how that process is going to take place. I need to probably talk to them about what their normal procedures are for it, whether it's posted they post the report. I'm assuming they're going to repost the report for the public or for everybody to see. And then we'll have to look at it internally. How we publicize it, what kinds of comments is yet to be determined. We can think about that. And, I understand you probably want to have some input into that or something. But basically what we'll do is we'll look at it. It will be evaluated by our scientists and medical physicians that we have access to internally. It'll be looked at by my bosses, and we'll, we'll adopt what we can. What would prevent us probably would be if there's logistical problems or there's legal problems. But I just don't know their process at the end very well yet. I can look at that and get back to you.
So right now, we don't know how we're going to have, when they get to the point that they've got a finished product, my guess is they're going to probably talk to you guys before they put it out there, so it's not a debacle of people hit he said, she said.
My presumption would be that it's going to work very similar to how we've done contracts in the past of this nature, whereby they will generate a report. It'll obviously have to be a public report at some point. You'll get it, and regardless of what we do, I'm sure you guys are going to have your own input on it. And then we're going to have to look at both the input that you all will give us, our assessment of the evidence, and make an informed judgment. And because we don't know what they're going to say, it's kind of hard to know, because they could come back with something that you all don't like at all. And so does that mean that we adopt it? Or, so I mean, it's going to be something where I think
it's
going to take some time for us to figure out, well, what impact do their recommendations have, and do we want to actually implement any of it?
And I don't know if they're going to let us review it before they give it to us or not. I don't know that the answer to that yet.
So the contract doesn't say you guys have review rights?
No, we don't get to tell them what to say.
Okay.
They will tell us whatever they want to say.
Okay.
They might show us as a favor, or as a courtesy. They might give it to us.
We're all very anxious to see what's going on with that, because the SEM process has been cumbersome, and having been working with that for a number of years. And then when I do provide information for the SEM, it may or may not match with HAZMAP. And so for the meantime, while we're waiting for this new report to be worked on, is HAZMAP going to continue to be linked to the SEM, and the SEM's going to, that contract's going to continue?
Yes.
Okay.
Yes.
In child case survivorship, incapable of self-support, before the claimant died, Social Security had determined that they were disabled. Why can't you accept the Social Security determination of being incapable of self-support?
We often do. But sometimes, oftentimes, if it says that they were incapable of self-support, a year within the time frame, they had to have been at the time of death. They had been incapable of self-support. That's one of the primary...
in our procedure manual, basically, it's a medical question. If the medical documentation supports that person was incapable of earning a wage, then they're incapable of self-support. If Social Security has made that determination, Social Security had to have relied on some sort of medical documentation to make that judgment. So what we generally say is, just because you show up with somebody that says you're earning Social Security disability, what was the basis?
We usually can get the background from
it. We usually can get it, but we do need to, it's a question of medical. That's what our procedure requires. Medical documentation to show you were incapable of working. Social Security generally relies on the same thing. But just because SSA has a rule about how they determine disability, we still need the medical documentation. So
we can usually get that from them. If they've given it to them, they should have it.
It's very rare that we can't in those cases, because generally when you have a disability funded by SSA, SSA's got the records. So,
well, what if they're just referring to the medical? They say,
we try to get it from
them. Because of your COPD and your asthma, you are disabled. And that's all we have, and we're trying to do wage loss. And we can't get a doctor to go, well, I wasn't even seeing you back in 2000.
Wage loss is different.
Yeah, but he's talking about incapable of self-support, so there's two different things here. We can rely on it for that. Oftentimes we will ask them for the additional backup, but most of the time when we have that document, we'll accept that incapable of self-support.
A similar one, Veterans Administration has listed a lot of things through their studies, Agent Orange and so forth, one of which, like prostate, can be called by certain things. Why isn't that accepted and on the SIMS?
They have a different standard than we do.
What is your standard versus theirs? I mean...
The VA did their own study, and they have their own standards. If they come out and say something's related, that does not mean that they're using the same standards that we are. And so we have to look at our law, and, for the SEM, we're looking at causation. And we need to verify the studies. The fact that VA came out and said something, we have not been able to come up with the same findings. It's a different, they have a different standard.
I think the answer to that is with both questions. We're not guided by the rules that are in place by Social Security or VA or anybody else. We operate on our own rules. That's why, while it's nice that Social Security we can get those records from Social Security or the VA, and it would be helpful probably for us to take a look at those records, we've got to adjudicate these cases based on our own set of criteria. And those don't necessarily align well with whatever statutory provisions SSA or the Veterans Administration is operating under. But we certainly would like to have that information, like I was saying before. And I think what Rachel is reiterating is, the more information that we have, the better off your claim is going to be, because we have a broader understanding of what's going on in the case. Just because the VA accepts something or SSA accepts something does not obligate us to do that.
Now, I want to piggyback onto those two, because you're dealing with 3 cabinet-level departments, HHS, the VA, and DOL, of course. But the illnesses are the illnesses.
There's different laws. We all operate by different laws. Even though we're all federal, doesn't mean we all operate by the same set of laws.
Okay, because and I'll just make this brief comment, that it almost seems like reinventing the wheel when one of the other cabinet-level agencies has already been through it. So even if you don't, let's say, eat it all in one bite, it would certainly, at least from where I sit, and I'm not sitting where you are, that at least know what process they went through, and then determine how applicable it is to the laws and other regulations that govern the union.
Other questions? Yes?
One of your questions dealt with, I believe, clusters is what it was called. What path or road can you lead me down if I have a large number of people with a common illness in a small group? Where can you send me? I mean, who can I talk to?
Well, we just have to, all I can tell you is that we have to adjudicate each claim on its own.
I understand, yeah. I know
In terms
you guys,
of clusters, I mean,
surely somebody in the
NIOSH probably looks at clusters to some degree.
The problem with cluster studies is the fact that, it is obviously something that you have identified, and it is certainly something that might have some sort of scientific credibility to be evaluated. The problem with cluster studies, as far as I can understand it from my limited scientific knowledge, that, cluster studies are just that. You have a grouping of people that have a commonality, an illness that could be associated with anything. In a worker compensation realm, of course, the first thing people say is it's all due to, they were working at this site, they all have this, there's something in their work. That has to be tested, that has to be controlled for, that has to be evaluated. And if that study determines that, yes, there is something in that person's work that's causing that, that's very useful to us. The thing you're asking is, how do I take this unusual grouping of individuals that have this commonality and have that scientifically assessed? That's not something we can do.
It might be HHS, somewhere at HHS.
That is a screening issue that the Department of Energy might look at.
Yeah.
That might be.
I think it would be HHS probably.
It could be any number of organizations.
Yeah, but not this part of NIOSH, but another part of NIOSH probably.
I went to the board because I saw a cluster of pancreatic cancer. I have a lot of posthumous claims that I represent. I went to them, and then we pushed through for part of the SEC that just got approved because the local news reports were talking about the contamination. These were unmonitored laborers digging trenches around this laboratory building that we now know as ground contamination. Those claimants are being paid because the SEC was extended because we kind of linked up all the dots. But that was like a 2-year process.